Judge Shapiro, we still have a couple of minutes, but we do have one of the parties. Your video is showing. I just wanted to let you know.
I see.
Judge Shapiro, it looks like we have both parties as well as the court reporter available whenever you're ready to get started.
All right, thanks, Morgan. I'll just get going here. I can figure it out. Good morning.
Good morning, Judge.
How do I put my camera on here? There we go.
Good morning, Mr. Bladen. Can you hear me?
Yes.
Maybe not. Oh, very good. Mr. Danson, good morning.
Good morning, Judge. How are you?
Fine. I guess we are all here. You guys ready to go?
We are.
I'm going to call the case. Okay, very good. I'll call the case. And this is a plaintiff's motion to compel. And so we'll hear from plaintiff first. This is Esparza v. MDOT Court of Claims number 21-228-MD. Mr. Danson, go ahead.
Good morning, Your Honor. Without having to repeat everything that's in my motion, this is a alleged roadway defect claim We've been trying since the beginning to get as much data as we can on the roadway, and specifically, my experts would like to inspect the roadway to determine if there are contour irregularities. My idea of doing so is requesting the prior data that might exist on the roadway that might show any roadway defects, and an opportunity to inspect the roadway in question.
Is that the,
There,
and when you refer to the data, is that LIDAP?
the LiDAR
LIDAR,
scan,
LiDAR, is that how you say it?
LiDAR,
Okay.
I was of the understanding that a LiDAR scan had been done. Mr. Bladen then informed me that there was no per se LiDAR scan, but rather there was a ride quality scan and data that was in the possession of one of the defendants in the circuit court case, Ajax Paving. That was one of the contractors for MDOT. Since the pendency of this motion and Mr. Bladen informing me that that ride quality data was available through another party, I issued a subpoena in the circuit court case. It's about last week I issued the subpoena, and I'm hoping that Ajax Paving, through their counsel, supplies me with that raw data so my experts can look at it and determine whether there are any contour irregularities in the roadway. I still reserve the right to do an inspection of the roadway, which under discovery rules, I'm clearly entitled to.
Well, let's say I wanted to, if Mr. Dancing, if I wanted to give you relief, what are you asking for then in terms of, do you want them both? You want one, maybe the other?
I want the ride quality data because the LiDAR scan doesn't exist now. And I want my experts to be able to look at it. That would not require a ruling from the court because I've already subpoenaed that from an independent party. But I want to reserve the right for an inspection. And if the data doesn't give me what my experts are looking for, the only way I'm going to be able to determine if there's any contour irregularities in that roadway is through an inspection, which MDOT doesn't want me to do.
All right, well, listen, I had to move from where I was sitting to maintain my connection. So hold on a minute, I want to get my paperwork.
I have to do something about these overhead lights. They always create a glare on me whenever I'm doing these.
All right, thanks for your waiting. All right, Mr. Danzig, let me ask you a couple of things. So it sounds like what you're telling me is that you agree, you don't dispute that the LiDAR documents that you sought to get don't exist and apparently never existed. Is that right?
That's what Mr. Bladen is telling me.
All right. Well, I doubt very much he would misrepresent that as an officer of the court. So how, if at all, does that affect, in your view, the defendant's argument under 23 U.S.C. 407 that these materials are not discoverable pursuant to federal statute?
Well, the LiDAR scan might not be discoverable pursuant to government statute, but I certainly am entitled to inspect the roadway to determine alternatively if there's any deficiencies in the roadway. And if the argument is I'm not entitled to the discovery and I can't access the discovery, which I don't think they're saying, then I'd say I want my inspection.
Okay. And in terms of the inspection, what kind of practical issues from your perspective are we dealing with? Though I imagine that Mr. Bladen has more to say about that probably.
I think the practical realities are they're going to have to shut down a couple lanes of the highway. It's cumbersome, it's difficult, but they've done it many times since this accident over the last couple of years. And they do it for any number of reasons. And if they have to shut down 2 lanes to allow my experts a certain reasonable period of time to do an inspection and quite possibly our own LiDAR scan, I think that it's doable. It's cumbersome, but it's doable.
Well, let me ask you then, what do you have an estimate? Have your experts given you a sense of how long they're looking to have access to the roadway once they have access?
Yes, 3 to 4 hours. And we could do it at an odd hour or a different day, certainly not, major highway thoroughfare hours. We could do it
But
on
daytime, I presume.
We could do it in a nighttime. We could do it in an early Saturday morning when there's very little traffic. I would be very accommodating in that regard so that it's least cumbersome and least intrusive.
And what is it your experts think they'll find or hope they'll find in such an inspection?
I'm not sure that they're anticipating what they're looking for, but what they're really looking for is a contour irregularity where water would be accumulating in it's not a hole, it's an area of unevenness that has a propensity to accumulate water and can be a danger to vehicles upon the road.
Okay, one other question I had is Mr. Thompson's full deposition in the record? I just have the 2 excerpted pages.
Yes.
That Mr. Bladen has presented. It is in the record? Okay.
Now, it is, and I would say to you that it's not the only version. My client's testimony is going to be taken, Mr. Esparza, in the next few weeks. And I'm not so sure he's going to have the same testimony as Mr. Thompson.
All righty. Let me see here. All right. Let me turn then to, it's Mr. Bladen, right? Am I saying it right?
Yes.
All right. Very good. Why don't you go ahead and proceed? And you've heard some of my questions. I'll have some of the same ones for you.
Well, the first thing I would say is it sounds like counsel is conceding that the ride quality raw data is probably precluded from discovery under the federal statute. And then in the alternative, he's saying, well, then give me a LiDAR study of the road. I think that this motion is a bit built on a faulty premise, which is the assumption that there actually is a defect there to actually be looking for. I think counsel's phraseology as he was describing what it is that they were looking for and want to accomplish here is a giveaway here. What they're saying is they're trying to find a defect. They're not saying we know one exists or we suspect one exists because we have evidence that one exists, that we have photographs or eyewitness testimony, or we have expert affidavits. Or by the way, it's interesting that, he could have attached an affidavit from Mr. Esparza contradicting what Mr. Thompson testified to in his deposition to either this motion or a motion for summary disposition, but he didn't do so. He wants to hold that ambiguity in reserve, I guess. But I think, when we have a motion pending, he's obligated to contradict the testimony with something. If Mr. Esparza disagrees with what Mr. Thompson testified to, he ought to be saying that in an affidavit in response to the motions. But what I would say here is the plaintiffs here, in their motion, in their complaint, and in their notice of the highway defect, specified a specific defect of condition, a bird bath condition or a subbase depression that arose while the I-75 was being reconstructed in the segment 1 phase due to mechanism being a barrier wall collapsing of somehow and creating this. And the source of that information was Mr. Thompson, or allegedly was Mr. Thompson.
Well, let me stop you there, and maybe plaintiff will have to answer this later. But what did I only have the 2 pages from his dep? What does plaintiff say Mr. Thompson said?
I believe
I saw the little thing from the job interview, but it wasn't clear to me.
Yeah, I believe we attached the entire deposition to our summary disposition motion. So I apologize if I didn't attach
My
a
problem.
bridged version to this motion. So that would maybe my fault on that regard, but
I'll read it.
But he denied ever seeing that. In fact, what he said was his only work for MDOT was on segment 2, which has nothing to do with this accident. I think we all agree with that. And that he, as an MDOT employee, that he had nothing to do with segment 1. That what he described was problems with the barrier wall on segment 2. He did work as a subcontractor on sub parts of segment 1, but he was asked in his deposition, did you recall ever seeing any of this happen on segment 1? And he said no. So he doesn't have any recollection of it. I believe what happened is that Mr. Esparza misheard what Mr. Thompson said or misinterpreted it. I'm giving a charitable benefit of the doubt explanation here since we don't have his testimony. Mr. Esparza was at Mr. Thompson's deposition. So if there was any objection to anything Mr. Thompson said, I didn't hear it then. He could have attached an affidavit contradicting. He had plenty of time. I mean, this court is well aware that you can't contradict something with nothing. And saying, hey, Mr. Esparza might contradict what Mr. Thompson said in his deposition in a deposition that's going to be held in 3 weeks and not actually attaching any testimony to that effect. I don't think the court can rely on that. So Mr.
Esparza is scheduled for 3 weeks from now. Is that correct?
He is in the circuit court case. Because
which is against the striking driver?
Yeah, and the contractors.
Quite frankly, all the depositions are being co-noticed so that they don't have to be duplicated, but Mr. Bladen has not chosen to participate in the plaintiff's deposition for his own reasons.
All right,
well, I explained the reason in my email to counsel, which was that we have a pending summary disposition motion, and I didn't want to take their depositions while that was pending. And I reserve the right to take it later on if necessary. So, and
I guess, should we reach that point, then I'll rule on that.
Yeah, I understand, Your Honor. Just keep in mind that Mr. Esparza, the plaintiff here, one of the plaintiffs, is a longtime MDOT employee. And out of respect for him, I don't want to put him in that position where we're, cross-examining him unnecessarily if I can avoid it. But if so be it, if we have to do it, we have to do it.
He doesn't seem to share that concern about suing his former employer, but that's fine.
I get that, and I do want to make one thing clear here. Going back, and I don't want to talk about our summary disposition motion too much here
I've read it, so it's okay.
Yeah, it does inform this motion to a certain extent because, as I was pointing out earlier, the virtual entirety of their specifics of their allegation of how the accident occurred or why it occurred derived allegedly from Mr. Thompson, who then said in his deposition under oath, no, that's not how it, I don't remember that. I didn't remember seeing that, or I was talking about something else, part of segment 2. As a consequence, not only did Mr. Thompson deny essentially what was in the notice and in the complaint, MDOT attached an affidavit to its motion for summary disposition from its construction engineer, who said he reviewed all the construction records and personally inspected the highway and said there was no such defect. And also there were 2 warranty inspections done of the pavement that didn't show any evidence of that defect. So now we're in a situation where we haven't had an affidavit from any of the plaintiff's experts saying, we know it's there, we just want the details of it from MDOT's records, or to show that they knew about it or something like that. This is essentially them saying, we want to see if it's there or not. And I don't think they can do that. They have to show there was actually something there to begin with before they can say, we want to go on a fishing expedition to find this.
Well, obviously they wouldn't have to go on a fishing expedition, as you call it, if this was a regular road. I mean, they could just send their people out there. And I mean, the difficulty that brings us here is that it's on a highway. So they're not in a position to independently go out there and determine factual information that they might bring before the court. I mean, wouldn't you agree with that?
I don't necessarily.
I'm not saying it's there.
I don't necessarily agree with that.
Like it would be foolhardily to run out in the middle of the highway.
Yeah, I don't necessarily agree with that. I mean, there's nothing, I mean, a lot of times, for example, you'll have a police report that says, we found a chunk of concrete, or we
Sure.
found a pothole, or something to that effect. And so there's at least some sort of question of fact about that issue. Whether it came from the road or not, or whether or not that was the cause of the accident is a separate issue. And that's a question of fact. But here, what we have is a police report that not a single witness or investigator said there's a pool of water on I-75, and we think that might be the cause of this accident. That not in
Okay.
there.
Okay.
I hear you. I got
And by the way,
wait, Mr. Danzig, hold
Sorry.
on.
There's
Go ahead.
dozens of photographs of the accident scene that don't show a pool of water either. And I didn't attach all that stuff to the motion. I didn't want to bog the court down with having thousands of pages of things to look at there. I tried to be concise. We only had a 20-page limit. So I think,
You may,
as I said,
you may learn that I'm unfortunately flexible when it comes to page limits. I tend to grant those motions, but in any event, I understand,
well,
and I appreciate that.
I appreciate that, Your Honor.
But I do have two other questions. One is, I'm unfamiliar with 23 USC 407, and it may be that plaintiff's counsel is conceding that. We'll find out. But is there any question that you see, Mr. Bladen, as to whether this falls within 23 USC 130, 144, 148, which seem to be the statutes that the data has to have been compiled in relation to? I don't know what any of those things are. I just was reviewing the statute this morning.
I'm trying to think about one of them. I think it was 148. I'm not certain. 130, I think, is highway crossings. 144, I believe, is for bridges, or I may be flipping 144 and 148 around.
That's fine. Okay.
And 148 is the for highway safety improvement projects, and there's a list there. But I would say that the language of the statute says it falls under one of those statutory categories, or includes specific highway improvement project on a federally funded, highway or something to that effect. I don't have the language in front of me. I apologize.
That's fine.
I think it's more inclusive than just what was under those subsections.
Okay.
But again, I think that's almost a moot point, because as Mr. Danzig talked about, they can go and get that raw data from Ajax, apparently. I spoke with counsel. I said, do you guys have this in raw data? Because all we had were these large scrolls, and it would be like doing a Torah reading for 3 weeks, trying to copy all this data down. I don't even know if the data is in squiggly lines like in a Richtergraph, or if it's in numbers or what. But apparently Ajax has this in digital format, and it's more reproducible. And Mr. Danzig has subpoenaed that record. So even if it was not something we could produce, they have access to it through another source anyway.
All right. Now, if I were to grant relief to the plaintiffs on the inspection, what's involved as a practical matter from your side?
Well, I'm not sure exactly. I have to rely on what Mr. Danzig is saying as far as what the inspection would be. It depends on what it is. Are they just doing a drive-through LiDAR study, or they actually want to shut down the road and personally go out there and do measurements or inspection? That's the nature of it.
I can answer.
Well, let's assume they want to do an inspection.
A personal inspection of the highway?
Yeah.
Yeah, they'd have to shut down I-75, which is one of the major arteries in Michigan, for a period of time.
I'm acquainted with it.
Yes, I'm sure you are, of course. Which would require a lot of advanced planning, because you have to have it properly shut down to advance warning of traffic, to all kinds of signage, safety vehicles, all kinds of things that have to go out there. Normally, we do this through a permitting process, and they'd have to go through a permitting process. They probably have to obtain some insurance in order to do this. I don't know what the cost would be. They'd probably have to pay for the permit, and they'd have to probably supply their own costs to do that. I'm sure they're willing to do that part of it, but it is burdensome. But I think the issue here is And I can understand if the court's saying, well, the burden is reasonable because this information is vital to finding out whether or not, in order to establish a question of fact. I don't think it is. I think the problem.
I got you. Mr. Bladen, I got your argument, and I hear you, and it's a pretty good argument, so I'm not discounting it. I just want to get answers to all the questions while I have you here in front of me.
Yeah, I appreciate that, Your Honor. So, yeah.
So if the state were to do this, do they have costs that they would want the other side to pay?
Well, I think there would be, there's probably a permit fee. I don't know what that would be.
You don't have like a manpower fee or something like that.
Well,
whatever.
There's also additional, there's additional costs on the public of just shutting down the road and slowing down I-75.
I understand.
We're going to get, even though we can't recover that, the public is going to get mad at us over it. That's just the nature of the beast.
I understand.
So
I'm mad all the time at MDOT when I drive around in the summer. I'm grateful too.
I always joke about that. That the public gets mad at us when we have potholes, but they also get mad at us when we shut the road down to fix the potholes. So the MDOT really can't win no matter what it's doing. But that's the nature of the beast. It's the public. It's a public cost. It's not something the MDOT directly can recover. Although when we do contracts, we have like lane rental fees, and we have, if you delay opening the roadway, we charge you extra money, or contractor. That's not really an issue here. So it's more of just a burden on the public.
Gotcha. All right. Is there anything else you wanted to cover before I go back to Mr. Danzig with a couple of questions?
Yeah, just briefly, I don't think that state police report study thing really sets up a question of fact either. We all know what was going on in 2020 in the state of Michigan and why you might have lower traffic rates there. And, it would be better if we could compare 2019 to 2020 and 2021 to see whether it was just a revert to the mean or if there was actually something there. In addition, this roadway's been open since September of 2017. So the statistics, we need to get 17, 18, 19 in there to see whether there's actually anything to this.
Well, where's that data?
Oh, I think the state police has it. I think I reviewed, the state police they put out a press release about an increase in actual across the board accidents from 20 to 2021. That's not part of the record, so I'm not gonna belabor that, but you can imagine the logic of that would be the case. And also I want to point out, Mr. Danzig, again, what are his experts looking for? Something that's collecting water. Again, that goes back to our summary disposition motion, but why are they looking for something that collects water? Because I think they believe that's the mechanism that caused the accident. Well, they have to show it's a defect all the time, not just when it's collecting water.
Okay. All right, Mr. Danzig, I got a couple of questions for you, but go ahead with what your reply, and then if you don't get to it, I'll ask you.
Thank you, Your Honor. First of all, my client, I expect to testify regarding, and the question was raised, well, he's going to say that this is what he understood Mr. Thompson said. So Mr. Thompson testified that he wasn't involved with phase one. He didn't say that there was a barrier wall that collapsed, that caused the roadway defect. Mr. Esparza is going to say what he heard and what he believes Mr. Thompson told him. Second of all, it's always been, and I don't have that testimony yet, so it's hard for me to establish that there's a record of a testimony being taken, but I've been waiting for the testimony of Mr. Esparza, and he will testify whatever he testifies to in a couple of weeks. But it's always been my goal to get data that will show whether there is or is not a defect there. I was always of the understanding from Mr. Bladen that a LiDAR scan had been done. All I was doing was requesting the data that my experts could look at. And if there was no data, let us do our own LiDAR scan. It's not the goal of my experts to go and do an inspection of the roadway because you need a scan of the roadway to determine if there's any defect. Visually, you can't really make such determinations without the scan. So my goal here is if the court were to allow us to do an inspection, it would be by hiring the vehicle that does the LiDAR scan to roll through the area, a designated specific area with a designated time constraint that does a scanning of 2 lanes of the roadway, the center lane and the left lane, where these cars went out of control.
And does that have to be done when the road is closed?
It would have to be done
Those two,
while the road
okay.
is closed because they're going at a very slow pace.
Okay.
And there'd have to be some barriers set up. So that would be the confines of that, not people on the roadway doing an inspection, but rather a vehicle doing the scanning with its electronic equipment. And then are my experts reading and interpreting that scanning equipment and determining whether there's defects on the roadway. That's the goal. And if I didn't have to do that, I'd be much happier because I could just give this data over to my experts and they can say, yes, there's a defect and a problem there. No, there isn't. If no, there isn't, this court of claims case is going to get dismissed. There won't even be a summary disposition motion hearing because I will voluntarily dismiss this case if my experts tell me the data says there's no defect. Then all I have is my
what do you know
case pending.
What do you know about the Ajax data and whether or not that covers what you need?
Only what Mr. Bladen has told me, which isn't a lot. And he has told me it's a ride quality data study. And I don't know it's the equivalent of the LiDAR scanning. Maybe he can shed greater light on the usefulness of this data that I have subpoenaed, and I don't know what it's going to show.
And when do you anticipate, absent an objection, receiving the material?
Within the next 7 to 10 days. The subpoena is issued for a 2-week response. It's been almost a week, so I expect they're accumulating. I haven't heard an objection yet.
And then you have to send it on to your expert.
Correct. And they're anticipating receipt of it and reviewing it as soon as practically possible. They've been waiting for any data to review.
Okay. And I know this is really pertinent to the ST motion, and if you're not prepared to discuss it, just say so. But do you have a response today on the Hansen issue, which is you may find a defect, but under that case, it may not have occurred at a time that is actionable?
I believe our SD response has addressed that issue, Your Honor.
Okay, all right.
I differ on the law with Mr. Bladen, obviously.
All right, let me look at my notes for just a moment. Bladen, you said there were dozens of photos of the accident scene. Were those taken by the police on the evening of the accident or day of the accident?
Yes.
Okay.
If the court permits, may I address the question of the data?
You may.
Okay.
I'm pretty open. Go ahead.
All right. Thank you, Your Honor. Actually, so the data that's at issue here is what's called raw data from a ride quality study that was done probably 6 months or so before the roadway was reopened by MDOT and certified to be reopened by MDOT.
Is what happens at a ride quality study the same thing that happens in a LiDAR scan?
Well, my understanding based on, okay, I was trying to explain the background of all this and where it's coming from.
I'll shut up. Go ahead.
So when we produced all this ride quality study information without, not the raw data, but everything else related to it in our initial disclosures, in fact, with the exception of a couple of inspectors' daily reports, which we supplemented later on when we filed our response to their first discovery request. We produced basically virtually the entire construction file for this segment 1, which is thousands of pages of documents, plans, specifications, all that kind of stuff. After we had this Mr. Thompson's deposition, Mr. Danzig said, we still need to have more information regarding the roadways. He's basically explained what they're looking for here today. And I said, well, I went back through the records that we had already produced, and I saw the ride quality study, which does, with the purpose of it, is to basically show undulations in the roadway that are then smoothed out by what's called diamond grinding. And there was a diamond grinding operation that was done. And these are Excel spreadsheets showing measurements at every 1/10 of a mile, I think, something like that. And they're measured against what's the International Roughness Index or something like that, sort of a standardized methodology that engineers use to determine the roughness of a pavement. And so any areas that exceeded the roughness index at the time would then be ground down to be within the tolerance levels. So we produced all of that. But what I found is, so I pointed that out to Mr. Danzig and said, hey, you might want to have your experts look at this to see if that tells them whether, that will give them the comfort of knowing that there was no defect here, because in accordance with what Mr. Thompson testified to. He presented it, I understand, to his experts and wrote back to me saying, we need the raw data from that study. And I found that's where this whole data issue is about. And they sent out a request for production of that, et cetera, which we just responded to, I think, a couple weeks ago, with our same objections that we're doing under our motion here. But we only had that data in the scroll form. And that's why I said it's this big scrolls of paper, which you can't just send over to Kinko's or something to have them copy it off the running, copy machine. You'll have to inspect it, is the only other alternative, really. And then, but that would take, I don't know how long, and I don't know what the format of the data was. Oh, okay.
Sorry about that.
Yeah, I wasn't sure if you were still there, Your Honor.
Someone's trying to reach me. Go ahead.
And so what I found out was I checked with counsel for Ajax and asked whether they had this in any better format, like digital format. And it turns out they did. And then I brought that to the attention of Mr. Danzig so that he could request it from them. And I want to get it too, frankly. But I think that the general gist of this is, I don't think that from what I'm gathering from his, and I don't want to get into us, being entitled to supplement or any responses from their experts and so forth, which we are, if they've come to, have any conclusions. But I think you're hearing Mr. Danzig saying again and again here, they just want to see if a defect is there.
Right.
I think for purposes of this case, they have to know there's one there before they start doing this stuff.
Well, just as I sit here to let you know, I mean, my inclination would be to, kind of let you get that Ajax material, let the plaintiff's deposition be taken before I order any type of inspection. You may not be entitled to one, Mr. Danzig. I don't know at this point. So to me, it's a practical issue of how to proceed. I could give you time, Mr. Danzig, for your experts to review the Ajax material and Mr. Esparza's deposition. And then if they need something further, I think I need an affidavit from an expert explaining a theory of the case and why an additional LiDAR study is required, why the materials produced data are inadequate to answer the question. If either of you think that's a bad idea, say so.
Well, I mean,
I can accept that idea, Your Honor.
Well,
I'm hoping that the data will allow my experts to arrive at conclusions, and we can do what we need to do at that point in time. I'm really hoping that's the case.
Yeah, and you're still going to have to, we'll still have to schedule that SD motion, because regardless of everything else we're doing here, that Hansen issue is is one that concerns me. So, but I would prefer to have the discovery issues resolved. I understand the state would like to have the SD motion heard first, but that's just not how I am inclined to do stuff. It may be that there's no more discovery, and then I'll rule on the SD motion. But if there's going to be more discovery, I don't want to be in a situation to have preempted it. So, Mr. Bladen, I cut you off there. Do you want to say something else about it?
Obviously, we'll respect whatever the court rules here. So, but I would just say the time for them to produce Mr. Esparza's testimony was either in response to our summary disposition or in response or in support of this motion. There is such a thing as an affidavit. You don't have to go through a deposition. And I presume that Mr. Danzig has access to his client. This is not a situation where you've got to get a third-party affidavit from somebody and it's difficult. So I'm a little concerned about that.
Would you rather, Mr. Bladen, that I just had Mr. Danzig produce an affidavit from his client along with the and look at the Ajax materials rather than have the deposition at this point? Well, I'm not gonna rule against him because he doesn't have an affidavit in his hand today.
Okay.
And if that's the case, why wouldn't his testimony be sufficient as opposed to an affidavit that I would draft in lieu of his deposition? Why don't we just see what he has to say?
I would think that's wise, so at least you could cross-examine him, Mr. Bladen. But if you think an attorney drafted affidavit, since I'm not going to throw the case out today, would be preferable, I'm open to that idea.
Look, I see. Look, essentially, what's going to happen is Mr. Esparza is going to say, "This is what I thought he said. I disagreed with him." Right? Then I will then go get the other two people who were at the interview, who will then confirm that they confirm what Mr. Thompson said, and that will be they will argue, well, there's a question of fact about that, and I think that's frankly unfair.
Well, I don't even know if what was said to Mr. Esparza is admissible. I mean, but that hasn't been briefed, or maybe it has. I don't know.
We did produce some of this information under subject to a protective order for part. So, yes, I mean, I guess you could say that Mr. Thompson is an MDOT employee, and theoretically, it's not hearsay. Right. But there's notes that were produced by one of the other people. They will come forward and testify or give an affidavit saying, "Yep, those are my notes." I did not hear anything from counsel or Mr. Esparza after Mr. Thompson's deposition suggesting that there was anything that Mr. Esparza disagreed with at the time. I think this is late. And so that's my opinion about it. I obviously the court can, the court feels that it needs to get that testimony, but I think that's unfortunate.
Right. Well, I tried enough cases to know people don't always say what you think they're going to say. It's happened to me, and it happened to me for the other side. So one last question for Mr. Danzig. If you get that Ajax data, did you give me a time frame for your experts?
I would say 30 days.
30 days from now or receipt?
30 days from receipt, and I'd be pushing them because they're going to have to look at data and take whatever they're doing and put it aside and put mine at the top.
All right. Well,
and if they do that, I'll get it done in 30 days from receipt.
Your Honor, in the spirit of this hearing, if I may, we also get an agreement from counsel that they will do a supplemental interrogatory response with their expert opinions before the data is produced and then after the data is produced, because I want to see where their opinions are right now.
No, I'm not going to order. I'm not going to order that. I don't think it's required that the expert have a refined and defined theory until he's had an opportunity or she's had an opportunity to see the evidence they think they need. If it's something outlandish, that's a problem. But I'm not going to make them. I'm not going to make them do that. They'll have the material, and then if they have something that's viable, then they should supplement then and do so promptly.
I will.
All right, I will prepare an order. My expectation is that it's going to say that I'm going to give the plaintiff's experts 30 days following production of the Ajax materials. If the Ajax materials are not produced within 14 days of your subpoena, I'd like notice of that fact. Okay, Mr. Danzig, I need you to notice it and make sure that Mr. Blake has the same notice, in which case I might have to figure out what we're going to do, because I don't want to delay this. I think the defense is entitled to get the case kicked if it's going to be kicked before much longer. So you'll have that time, and Mr. Esparza's step will be taken within, when is it scheduled for? I mean, it's within 28 days of now, right?
I believe it's scheduled for the 4th. Is that
August
right?
4th.
Yeah.
Correct.
All right,
I
I'm
haven't
going to put
noticed.
that in the order.
Okay, I haven't noticed it up on our side yet, but I will do so. Following
Okay, would
the
you rather
hearing.
I just said within the next 28 days, or you want August 4 in the order?
Well, I mean, Mr. Danzig and I can discuss that, what makes
Okay.
the most sense.
Fine,
We'll
very
work it
good. And then, and following that, I will rule perhaps without a hearing on the SD motion, but depending on what comes out of this process, I may order a hearing. So, Mr. Danzig, could you prepare an order?
I can.
Okay, just to go over it again, 30 days from receipt of the Ajax materials, I need an affidavit or supplemental interrogatory answers from your experts or expert. And Mr. Esparza's step will go forward on an agreed upon date that I'll allow you to decide and put in the order. And that I think that's it. Did I miss anything?
I think there was the notice issue if there was some problem obtaining the raw data.
I apologize. Oh, yes. And that if you don't get a response, if the subpoena is not responded to fully within 14 days, that you'll send a letter to the court and opposing counsel notifying us of that fact. And then we might have to get on the phone and find out what's going on.
I'll draft that order. I'll send it over to Mr. Bladen for his approval prior to us submitting it to the court.
And the request for an inspection / LiDAR study by the plaintiff's experts themselves, I'm holding in abeyance till we see where we're at.
Very good, Your Honor. Thank you.
All
Thank
right,
you,
thank
Your
you all. And if you want to transcribe, the court reporter is here. So thank you all very much. The matter is concluded.
Thank you, Your Honor.
So I'll send something over to you.
All right, gentlemen, do we need a transcript?
I do not.
Okay,
And not at this time.
all right, great. I can, do you have my information or you'll be able to contact me? I can email you both with my email, and then
Why
if
don't you do that?
if you need it, just give me a shout.
That would be great.
All right, thank you so very much.
All right, thank you.
Bye.
Thank you. And Phil, I'd recommend you notice up the depth or
Yeah.
co-notice. Thank you.
All right.
I'll talk to you soon.
Okay, bye.
Thank you.